Please rise.
Nobody's waiting.
Out at the jail?
Nobody, I log off and log back in, make sure it's not up on my end. Well, that might, oh yeah, I was still under the Smith.
Okay.
You never turn it off.
Yeah, right.
Yeah, turn that one off and activate the session.
Recording in progress.
We should now have people in waiting.
Have you let anybody in yet?
Huh?
Have you let anybody in yet? I've got Tim Johnson, competency. Denny's co-counsel. I'll assume Denny will be in his office. But I've got a 1 o'clock here live too, so.
Okay.
Well, let me see what.
All right, got 6 people, including the Are you Jerry Howard there at the jail? All right. This is case number 20 CR 48, State of Ohio versus Jerry G. Howard. Howard is appearing by Zoom from the jail. His attorney is Danielle Witt, appearing from her office. Appearing on behalf of the state court office of the prosecuting attorney office. This is a pretrial, and I have been presented with a plea of guilty form. In case of how to enter plea of guilty. Now, Ms. Witt, you and your client each agree that he can appear by Zoom remotely rather than being personally present in the courtroom. You're agreeing with that, Mr. Howard?
Yes.
All right. The defendant's charge, as I said, was one count of aggravated possession of methamphetamine and 53 felony. Third degree felony. The matter is set for a trial on June 13th. I have received this plea, Mr. Howard, which says that you're going to enter a plea of guilty to the charge. I'll hold this up to this camera on the screen so you can see. You see your name there with the plea of guilty form and the charge. All right. This is a 3-page form. On page 3, almost halfway down the page, there's a sentence that says, "I enter this plea voluntarily." And right below that is a signature, which appears to be Jerry G. Howard. So I'll hold that up to the camera and ask you if that is your signature there that I'm showing you with my paper.
You can read it.
All right. When did you sign this agreement, Mr. Howard? When did you sign this agreement?
Yesterday.
All right, there at the jail?
Yep.
And was Ms. Witt there when you signed it?
Yes, you are.
Did she go over with you and explain everything to you and answer any questions you had?
Yes, you do.
Did you understand when you signed it, this agreement to plead guilty, which means there won't be a trial, the next step in your case will be a sentencing hearing?
Yes, I understand that.
And did you feel that you had enough time to fully consider this matter before making this decision?
Yes, you.
And are you entering into this agreement to plead guilty voluntarily?
Yes, you.
All right, the agreement states that you're going to plead guilty to the charge of aggravated possession of methamphetamine under section 2925.11 Ohio Revised Code 33 felony. Further states you understand that the maximum prison term for that could be 36 months in prison. The minimum is 9, and there's increments in between that of 9, 12, and every 6 months. There's a fine available of $10,000, a mandatory fine of $5,000, and a license suspension of 6 months to 5 years. It's not a requirement to be sentenced to prison, although there's a presumption that that's the appropriate sentence. You understand all that?
Yes,
And are you facing any felony charges in any other jurisdiction?
you.
Are you currently on community control, probation, parole, or post-release control for a felony in any jurisdiction? Right, now under the law, if you're convicted of this offense and serve a prison term, once you complete that term, the law provides that the adult parole authority could, at their option, put you in post-release control for a period of up to 2 years, which means that you will be supervised under the term they set by a parole officer, and if during that period of time they determine that you were not compliant, then they could return you to prison as a sanction, making sure that there's a period of up to 9 months for one violation. There is a cap of half of the prison term for all violations, but if there's a new felony conviction while you're under post-release control, then in addition to their sentence, the judge and application opposed, that judge would also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year where time left on that period of post-release control is greater. That occurs, that must be served consecutively with the sentence in the case. You understand that? Now, under the law, I'm not required to sentence you to prison. I can put you under what's called community control or probation. That means instead of going to prison, you would be supervised by a probation officer in the term set by the court for up to 5 years. And if during that period of time they felt you were not compliant, they would file written notice of that to the court. There would be a hearing. If you get a copy of it, you can be entitled to have an attorney. If the outcome of the hearing was you failed to comply, then at that time, the court would revoke community control and send you to prison for 36 months and fine you $10,000. You understand that? Right now, the charge in this case alleges that on or about December 10, 2019, in Highland County, Ohio, you did knowingly knowingly obtain, possession, use, a Schedule 2 controlled substance with methamphetamine in an amount equal to or exceeding bulk amount with less than 5 times bulk amount. Violation section 2925.11 Ohio Vice Code. And that's the charge of aggravated possession of a methamphetamine third-degree felony. Now, do you understand what it is you've been charged with, what the state said you did, when, or how they alleged you did it?
Yes, sir.
And have you discussed the nature of the charge, evidence in the case, possible legal issues in the case, possible offenses you might try to raise at trial, possible outcomes of the trial with your attorney?
Yes, sir.
You're satisfied with their advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Are you taking any prescription drugs?
I think, still going to try to take, PA. I think I'm taking, I'm trying to get, PA. But pretty much, like that.
Are any of those medications interfering with your ability to understand what's going on here today, or to express your opinions accurately, or to make informed decisions?
Thank you.
Right now, on page 2, there are 2 lines that are printed in bold and underlined, and it states defendant shall not plead guilty to the indictment. State defense shall not recommend community control and admission to police and drug court. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty here today?
Yes, sir.
Now, in the law, the recommendation of the parties, sentence is not binding on the court. So if you plead guilty, I'm not required to follow that recommendation. I could decide that you should be sentenced to prison instead of getting community control. You understand that?
Yes, sir.
Right, and then also, drug court is not something that the court will order you to, it's something you will have to apply for. So you will have to meet with the drug court coordinator and go over the program description, requirements of her, and then decide if you wish to apply to the program. And then the court will make a determination whether or not you would be appropriate for that document. Do you understand that?
Yes, sir.
All right, now, do you hold any license or certification from any state agency that regulates an occupation or trade or any specific occupational profession?
Mr. I'm retired from about the evening.
Okay, well, that'd be a trade group, but you don't have any government issued license for anything like that. Okay. Now, you have certain rights you must understand for an accepted plea from you guilty. First, you do have a right to counsel, and Ms. Litt was appointed to represent you. That wasn't simply work the case out, but provide any defense that could be available to you under the law that you wish to provide. So, you decide that you do not want to enter a plea of guilty, but you want to defend these charges, and she'll continue to represent you and defend you, including a trial if that's what you want. You understand that?
Yes, sir.
Now, in the Constitution, you have a right to have jury trial in this matter, Mr. Howard, in which 12 people will be selected from a group of citizens who live in this county that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, they be instructed on the law by the judge, and that jury of 12 will then decide by unanimous verdict between all 12 and have to agree as to whether or not the state jury is guilty. Now, if you did not want to have jury trial, which you did not want to plead guilty, you could waive in writing, which means you give up, the right to have a jury trial, and in that case, you have what's called a court or bench trial, meaning it would be the judge would hear the evidence instead of the jury, the judge would apply the law, the judge would decide whether or not the state proved your guilt, proved your reasonable doubt. You understand that? Right now, in the Constitution, you have the right to confront the witnesses against you and cross-examine them through your attorney. What that means is the witnesses against you have to come into court, testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney will ask questions. That's called cross-examination. The purpose of which is to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
In the Constitution, you have the right to use the power of the court to compel or force witnesses to come into court and testify on your behalf in the same state. So if you have witnesses you're not certain are going to come in voluntarily, you request the court issue a court order that's called a subpoena that forces those people to come to court and testify on your behalf if you want them to, even though they don't want to be here. And that's the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Now, under the Constitution, you have a privilege of self-incrimination, and you can't be forced to give evidence or testify in this case at any time, including the trial. No one can ever make a testify. The prosecutor can't, the judge can't, you decide. You decide not to testify. The fact that you did not testify cannot be used against you in any way by any person at any time. And no one's even allowed to comment about it except for one situation, and that is if there's a jury trial and you don't testify, the judge instructs the jury, but because that's your right, you cannot consider that for any purpose. You understand that?
Yes, sir.
Now, in the Constitution, you are presumed innocent of this charge, so proven guilty by the state of Ohio by proof beyond reasonable doubt on every essential element of the offense charge. So what that means is that the burden of proof isn't on you to try to show that you're not guilty of this charge simply because you're confused. In fact, under the law, you don't have to present any evidence at all for your defense. You may, it's not required. Whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
And are you a U.S. citizen, Mr. Howard?
Yes, I am.
Right, now do you have any questions about the charge and the possible penalty?
That's what I know.
You understand?
Yes, sir.
And any questions about the plea agreement?
Yes, sir.
You understand it?
Yes, sir.
You understand the recommendation as to the sentence is not binding on the court?
Yes.
You have any questions about the constitutional rights I've explained?
Yes, sir.
You understand those?
Yes, sir. I'm pretty sure.
Do you have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
No question, sir.
You understand?
Yes, sir.
Now, I didn't tell you this at the beginning, but if there's anything you would like to speak to Ms. Witt about before we go any further, I can put you and her into a breakout room where the two of you can talk, and without anybody else being on the screen and seeing you or hearing you. Okay? So you need to do that at all?
That's what I'm going to do.
All right? Have any questions about anything I've explained to you?
Yes, sir.
Then is it your decision to go forward and enter a plea of guilty pursuant to the terms of the plea agreement we've just gone over?
Yes, sir.
And as to the charge which alleges that on or about December 10, 2019, Hyman County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine in an amount equal to or exceeding bulk amount less than 5 times bulk amount violation section 2925.11 of the Ohio Revised Code. Charge of aggravated possession of methamphetamine, third degree felony, carrying possible prison term between 9 and 36 months, fine of $10,000, mandatory fine of $5,000, and possible license suspension of 6 months to 5 years, not included.
Guilty.
All right, court finds that in this stand open court, defendant was advised of all his constitutional rights, being willing, intelligent, voluntary, waiver the same, defendant criminal 11. Plea is accepted and a court filed. The defendant is found guilty of the charge as set forth in the indictment. Matter referred to the probation department for pre-sentence investigation of the same bond, and that will include an assessment for substance use disorder and mental health issues and treatment. And the sentencing date will be June 23 at 1 p.m. All right, is there anything further from counsel? All right, thank you. I think Mr. Thompson said next.
Tim Johnson, yes.
Bill. Case number 22CR047, State of Ohio versus Tim Joseph Johnson II. Are you Tim Joseph Johnson II appearing from the jail?
Yes, sir.
All right. Mr. Johnson, this hearing will be conducted by Zoom. It's an issue confirmed in the mental competency stand trial. He is represented by co-counsel Dennis Kirk is appearing on the Zoom in his office. And Mr. Armstrong is actually present corporately as the client's here. And the prosecuting attorney named Collins is appearing in her office. The court ordered a report as to the defendant's ability to stand trial and understand the nature of the proceedings, assistance defense, and also ordered the evaluation of the mental status of conflict defense. I received both of those reports from Dr. Aaron, E-R-I-N, Nichting, I pronounce it, Nichting, psychologist. And in her opinion, the defendant is found to stand trial, and there's no support for a possibility of insanity plea. Now, the attorneys for the defendant each had a chance to review the report, Mr. Armstrong.
I have, Your Honor.
All right, Mr. Kirk.
I did, Your Honor.
All right, Mr. Armstrong indicated you did as well. Ms. Collins, you read the copy as well?
Yes, Your Honor.
Does either party wish to offer any other evidence regarding the issue?
Defense will submit it on the report, Your Honor.
All right. Collins?
On behalf of the state.
All right. Well, then, based on the report, the court will find that the defendant is capable of understanding the nature and objectives of the proceeding and to assist in his own defense, and does therefore meet the requirement that he be found to stand trial. The court so finds, and the court will note that there is no basis for filing any sanction plea should that consideration. All right. So the case will be restored to the active docket. We'll go ahead and reset this. I don't think we have any scheduled at this point because of the evaluation. And has there been a previous time waiver other than the waiver caused by the filing of this motion?
If there,
The other waiver would have been his filing of discovery that they filed and not complied with our request.
Okay, so we're still holding it. Okay. All right, and his date of arrest was January 29th. Is that correct?
Thank you, Your Honor. Yes. It may have been the 30th, because that probably would have been after midnight, but 29th or 30th.
All right, I'm going to say it 29 for calculation. All right, Luke, reviewing the record, it looks like discovery was requested on the paper March 7th, whole time. Then the state complied, I believe, around the 14th of March, and then also on the same day filed their demand, which has not yet been responded to, which of course, also awaiting the competency order. The competency was ordered on, well, the motion was filed on April 12th. And so the whole time he was told until this defendant complied with the discovery request, so that would be 37 days of the 90 days expired. So that would leave 3 days pending. All right. Now, we actually had the first pretrial on this, that they was brought up for mental status prior to the start of pretrial.
Yeah, at least
No,
one.
he filed the motion for competency the day before the final pretrial.
Before the final pretrial, okay. So there will be a final pretrial and then a trial. Now, setting the pretrial, final pretrial, so that will set your motion date and the date to apply with discovery. And that will be set for June the 22nd. And trial date. No, actually, the time phrase was this discovery is about tomorrow, that'll be 12 for the deadline for July 8th. Trial. Alright, so the court will set the final pretrial for June 1st. And the trial date will be set for June 27th.
June what?
27th at 8 a.m.
Your Honor, I will be out of town that meeting.
Your Honor, I think it helps. I don't believe we had our client execute a time waiver before, although it's been discussed with him. If the court wants to, we'll be talking to Mr. Johnson the next day or two. You want to hold off setting dates and we can get a time waiver from him if that helps any.
All right, well, here's what we'll do. I'm going to give you a trial date, a pretrial first, and a trial date of June 16th. But if you get a time waiver, then I'll probably push that back. See, when is the Howard Mercer case set, Ms. Collins?
It was July 11th.
All right, so then I would set this for later in July, probably July 21st then. Okay. All right, any other matters to discuss at this time?
No, Your Honor.
All right, so your attorney should be discussing this matter with Mr. Johnson. Okay, thank you. All right, William Jordan, I believe, is next. All right, are you William Scott Jordan, appearing from the jail?
Yes.
In this case, number 22, CR 051, State of Ohio, versus William Scott Jordan. This hearing is being conducted by Zoom. This is recorded appearing by jail. The attorney is appearing in his office. Appearing on behalf of the state is the prosecuting attorney in her office. Mr. Jordan is charged in a 4-count indictment with burglary, grand theft, firearm, grand theft, breaking and entering, This is a final pretrial and our trial date is June 13th. I have been presented Mr. Jordan with a plea of guilty. Indication of plea guilty to counts 1 and 3. I'll hold that page up, the first page, to show you the document has your name, case number, it says plea of guilty, counts 1 and 3. You see that there?
Yes.
And on page 3, there is a sentence at the very bottom of the page that reads, "I know this plea voluntarily," and below that appears to me to be the signature of William S. Jordan. And I'll show that to you now on camera. It is that factor signature there in the lower left-hand corner of this document.
Yes.
When did you sign this agreement? Today?
Yeah.
All right. And when you signed it, was Mr. Perk there with you to go over with you and explain everything to you?
Yes.
And when you signed it, did you understand it's an agreement to plead guilty, which means there won't be a trial, and accept your case will be a sentencing hearing?
Yeah.
And do you think you have enough time to fully consider this matter for making this decision?
Yes.
Do you feel that you were rushed or pressured in any way? And are you entering into the agreement voluntarily?
Yes.
Now, the agreement states that you're going to plead guilty. First page, count 1, on burglary, 2911.1282, second degree felony, and grand theft, count 3, 291302A1, and revised code, a fourth degree felony. Further states, you understand that regarding count 1, the maximum penalty to be imposed by the judge is 8 years. The minimum would be 2. That'd be the minimum term. The law provides that for offenses of second degree felonies and above, that the Department of Corrections has the authority to extend the sentence if they think it's appropriate for up to half of the term that's imposed. And since the maximum term is 8 years that the judge can impose, that means that the maximum for count 1 that could be served is 12 years. So it could be anywhere between 2 is the minimum and 12 is the maximum on count 1. On count 3 is a 5th degree felony, 4th degree felony, and that carries possible prison term between 6 and 18 months, and fine of $5,000. Now, if convicted of both of these offenses and sentenced, then you could be sentenced to consecutive sentences. And so the maximum term the court would impose upon you would be 8 years on the first count, plus 18 months, which would be 9.5 years. That would be the maximum that I could impose. But if I gave you the 8 years, then on top of that, the Department of Corrections could add 4 more years. So that means the maximum sentence would be 12 years on that count, plus 18 months or a year and a half on count 3. So that means the total would be 13.5 years. You understand that?
Yes.
All right, now, are you facing any felony charges in any other jurisdiction?
No.
Are you currently on probation, community control, parole, or post-release control for a felony or any jurisdiction?
No.
Your Honor, I believe he's currently incarcerated.
Yeah.
Oh, okay. I didn't ask that question, so thank you. So, what are you serving a prison term for?
Receives stolen property and aggravated drugs.
From what county?
Claim.
All right. And so, what is your prison outdate right now?
August 11th, August 22nd.
Okay. So, if you're convicted of these offenses and sentenced to prison, the charge could be served consecutively to that sentence, so that would extend your time, whatever sentence were imposed. Do you understand that?
Yes.
Okay. Now, under the law, if you are sentenced to prison on these offenses, as to count 1, it will be mandatory that you be put under supervision, post-release control supervision, for a minimum period of 18 months up to a maximum of 3 years. As to count 3, it is optional up to 2 years, but we know that count 1 will require you to be in post-release control for between 18 months and 3 years as determined by the parole board. And that means you'll be supervised by a parole officer in the terms they set, and if they determine that you fail to comply, they can return you to prison. to serve the entire term that was ordered by the court for an additional period up to 9 months for any single violation, up to a cap or limit of half of the term that was ordered to be served by the judge for all violations. But if you commit a new felony while under post-judicial control supervision, then in addition to whatever sentence the judge can impose in that new felony for that conviction, the judge could also sentence you for committing that offense while under post-judicial control, in this case, for an additional period of 1 year, whatever time is left on the period of post-judicial control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the case. You understand that?
Yes.
All right, now, the court's not required to sentence you to prison for these offenses. Again, get what's called community control or probation, which means that instead of going to prison, you can be put under supervision for a period of up to 5 years. Under terms set by the court, and during that period of time, the probation department thought you were not compliant, they would file a written motion with the court, you would copy, and you would be entitled to have a hearing on that allegation, and be represented by an attorney. If the outcome of the hearing was that you failed to comply, then at that time the court would terminate community control or probation, and then sentence you to the 9.5 years minimum, which could also result in up to an additional 4 years in count one for 13.5 years, and a fine of $20,000 on top. You understand that?
Yes.
All right, now count one alleges that on or about May 19, 2021, in Hyman County, Ohio, that you did by force, stealth, deception, knowingly trespass, and occupied structure, or separately secured, or separately occupied portion of occupied structure. That is a permanent or temporary habitation of Scott Cooper, or Scott Cooper, any person other than a competency offender, present, like to be present, for committed the habitation of criminal offense. Violation section 2911.12A2 of the Ohio Revised Code, a second-degree felony. And then count three alleges on about the same date. He did the purpose of deprive David Shaney of his property, and only intended to control of said property with a 2008 John Deere tractor and other miscellaneous items. About the consent of David Shaney, the person authorized to give consent, that property being valued at equal to or exceeding $7,500, less than $150,000. In violation of section 2913.02A1, which is the grant up to the court. Now, Mr. Jordan, do you understand what it is the state has charged you with having done in each of those two counts, what, when, where, and how they alleged you did it?
Yes.
You discussed the nature of those charges, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise, trial, possible outcome of the trial with your attorney.
Yes.
And are you satisfied with his advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to make you plead guilty here today?
No.
Now, on page 3, there are 3 lines that are printed in bold and underlined, which I'll read at this time as follows. And it will enter plead guilty to counts 1 and 3. They will dismiss the remaining counts. State defense jointly recommend 3 years in count 1, consecutive to 12 months in count 3. Then it will pay restitution in the amount of $4,438.91 to Scott Cooper. Is that your understanding of the agreement?
Yes.
Does anyone promise you anything other than that in case you plead guilty here today? And Mrs. Collins, the state has consulted with the victims, both victims, in regard to this plea agreement.
Yes, I spoke with the victims myself on April the 11th, and both of them did approve this plea agreement.
Right. Now, Mr. Jordan, under the law, the matter of sentence recommendation is not binding on the judge, because that's up to the judge, not the parties. So even though there's an agreement between the state and you, that you should get the sentence of 3 years on count 1, second 12 months on count 3, that's not binding on me. So if you enter a plea of guilty, once I've heard all the information submitted, if I decide that's not the correct sentence, I could go ahead and impose a greater sentence of up to 8 years on count 1 and a maximum of 18 months on count 3 if I thought that was appropriate. You understand that?
Yes.
Right now, we have certain constitutional, let me back up. Do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No.
Right, you have certain constitutional rights to understand before I can accept a plea for the first you have a right to have an attorney. And I appointed Mr. Kirk to represent you not to simply work the case out, but provide any defense that we have to the law to likely provide. So if you decide you do not want to plead guilty, that you want to fight against the charges, you will still have him represent you throughout that process, including a trial, if that's what you decide you want to do. You understand that? Right now, in the Constitution, you have a right to have a jury trial in this matter, where 12 people will be selected from a group of 12 citizens that are subject to jury duty on your trial day. Those citizens will live in this county. After those 12 are selected, the others will be presented and instructed on the law. And then that jury of 12 decides by unanimous verdict, meaning all 12 have agreed on whether the state proves your guilt on either or both charges. Now, if you didn't want to have jury trial, you did want to plead guilty, you could waive the right to give up. Right to have jury trial, in that case, you'd have to call it a court bench trial, which means that instead of a jury there, this is the judge will apply the law, the judge will decide on the state prove your guilt, or prove your guilt on either or both charges. You understand that?
Yes.
Now, in the Constitution, you have a right to confront witnesses against you and cross-examine through your attorney, which means that witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions of witnesses, you can try and ask questions of your attorney. That's called cross-examination, and the purpose of that is trying to bring out evidence to help your side of the case. You understand that?
Yes.
In the Constitution, you have a right to use the power of the court to tell a court witness to court to testify to you, just like the state. So if you have any witnesses you're not certain are going to come in voluntarily, you request for a court order that's called a subpoena, and force those witnesses to come to court and be able to testify if you wanted them to, though they didn't want to be here. It's the same way the state witnesses are required to have the court. You understand that?
Yes.
Under the Constitution, we have privilege of self-determination, which means you're not forced to give evidence in this matter at any time with the trial. No one can ever make a testify. The prosecutor can't, the judge can't, you make that decision, and if you decide not to testify, the fact that you did not testify, you're not using this in any way, any person, no one is even allowed to comment about it, except in one situation, which is if there's a jury trial and don't testify, the judge instructs the jury clause that is your right to not consider it for any purpose. You understand that? Right, under the Constitution, the innocent of these two charges are proven guilty by the state of Ohio of every essential element of each offense by proof beyond reasonable doubt. So what that means is you're not required to try to prove you're not guilty simply because you're accused of these crimes. In fact, under the law, you're not even required to put on any defense in trial. You may, but you're not required to. But whether you present a defense or not, the burden of proof will remain upon the state to prove your guilt or proof beyond reasonable doubt on every essential element of each offense. Which is the highest burden of proof is known under the law. You understand that? Right now, originally you have entered plea not guilty, denied the allegation of the indictment, not committed as a crime. That plea exercised or invoked all the rights I have just described. If you change your plea from not guilty to guilty, that is the opposite of not guilty. Guilty plea against the allegations in the indictment admits that there are crimes you committed that crime. That plea gives up all the rights I've just described for you, except the right to have an attorney. You have the right to have an attorney no matter what your plea is. That exception. If you're pleading guilty, the way to give up, you right to a jury or court trial. The way to give up, you right to confront witnesses against you and cross-examine for your attorney. The way to give up, your right to require attendance of witnesses to come to court and testify on your behalf in the same mistake. The way to give up, your right to refer to self-determination, but you're the one that's saying you're guilty, and that's what you find guilty. The way to give up your self-defense, because the state you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court, which is what's likely happens if you're over a certain term. And it waives you up any right to file appeals you think you may have had up to the point of case. Now, if you should be sentenced to a maximum sentence or under certain circumstances, you can file an appeal. That would have to be filed with 30 days for sentence entry to be filed. You understand all that?
Yes.
And you are a U.S. citizen?
Yes.
And do you have any questions about the charge or possible penalties?
No.
Understand them?
Yes.
Do you have any questions about the plea agreement?
No.
You understand it?
Yes.
Do you have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea to these two charges here today?
No.
You understand?
Yes.
Now, I didn't say this at the beginning, but if you need to talk with Mr. Kirk about anything before we go any further, I can put you in into a breakout room where you can talk about anyone else seeing you here. You understand that?
Yes.
You need to do that?
No.
All right. Do you have any questions about anything I've explained?
No.
Is your decision then to withdraw your not guilty plea, plead guilty to the charge? count 1 and count 3 as, we've just gone through in this plea agreement.
Yes.
Right, and as count 1, which alleges that on or about May 19, 2021, in Manatee County, Ohio, you did by force, stealth, or deception, knowingly trespass in an occupied structure, except to secure or serve the occupied portion of an occupied structure. That is the permanent temporary habitation, Scott Cooper, or Scott Cooper, any person other than the office of the offender is present, likely to be present. Purpose committing the habitation criminal offense in violation of section 2911.12, A2 of the Ohio Revised Code, a charge of burglary, second-degree felony, carrying a possible sentence of between 2 and 8 years to be imposed by the judge, with the possibility that sentence be extended by up to 1/2 by the Department of Corrections. A fine of $15,000, county plea. And as to count 3, which alleges that on or about May 19, 2021, Manatee County, Ohio, you did purchase private name change his property going for obtaining the control of said property with 2008 John Deere tractor. Other miscellaneous items of 7 David Cheney, the other person authorized to give consent. Said property being valued equal to or exceeding $7,500 or less than $150,000. Violation section 2913.02A1, charge of grand theft, or to be nominated on prison term of 6 to 18 months on $5,000 that plea.
Guilty.
Right? Court finds on this day, no court defendant applies all constitutional rights. A no intelligent voluntary waiver of the same pursuant to Rule 11. Pleas are second or required. Defendant is found guilty of counts 1 and 3 as set forth in the plea agreement. Counts 2 and 4 are dismissed. All right, given the nature of the offenses and the fact that the offense already incarcerated on other sentences and other courts, court will not order pre-sentence investigation, and I will go ahead and proceed with sentencing forthwith. Anything for the state?
Only what's contained within the plea agreement, Your Honor.
There was no restitution for Mr. Cheney,
No, but they were able to recover the tractor.
right? And Mr. Kirk, we have defendant.
Thank you, Your Honor. Would ask court to follow the plea agreement. As the state did note, I believe the tractor and 1 firearm was recovered, so the restitution would be mainly out of the burglary case. The victims obviously are okay with it. My client had his first felony was earlier this year in Lincoln County. I'm not sure which happened first time, but in terms of his first felony conviction, he is 33 years of age, fell on some hard times, and does not excuse this by any means, but these were motivated by drugs. When I looked at his record, I even asked him what happened because he'd gone so long without any type of record until now. This all occurred on the same day in the same geographical area in Private County, and he has cooperated by taking a plea and saving resources. So would ask the court to follow the plea agreement. Thank you.
Mr. Jordan, anything you'd like to say? I see that you are from Waverly. What brought you up to Atlanta County to commit these offenses?
I was in a spine for that Clayton County, getting a lot of people from Clayton County.
Bad luck, huh? Okay. All right. Well, it is the order of judgment of court that as to count 1, the defendant B is hereby sentenced to the Correctional Section Center Court of Ohio for a period of 3 years. And as to count 3 for a period of 12 months, those sentences are ordered to be served consecutively, one after the other. The parties have stipulated to consecutive sentences further the court find that the offense is committed as part of 2 or more course of conduct, and a single sentence not have to reflect the seriousness of the crime, and the sentences are being imposed are disproportionate to the harm caused of the little sentence in count 3 and the lowest possible sentence in count 1. The court will also note that as count 1, that sentence of 3 years could be extended by 4.5 years by the Department of rehabilitation correction based upon their judgment, that it is incarcerated. These sentences are also ordered to be served consecutively with the sentence. In the Clinton case, for the same reason that these again courses of different courses of conduct, different victims, different counties, and the will not have to reflect the seriousness of this harm caused by the different victims. If one single sentence was imposed, then again the sentences are not disproportionate. And the court will further find that defendant's criminal history given us the crime degree shows that it's necessary at this point in Mr. Jordan's life to protect the public from future crime. Now, with regard to count one, once you complete the prison term imposed by the court, it is required by law that you be placed under police control for a period of up to, or for a minimum period of 18 months and an active period of 3 years determined by the health role. And during that time, you'll be supervised by a parole officer with conditions except as count 3 is a maximum of 2 years, but it's optional, but we know you're going to be count 1. Now, any event that they determine that you have failed to comply, they can return you to prison, making sure an additional period of up to 1.5, for up to 9 months for one violation, or a maximum of 1.5 if the sentence the court imposed for all violations. But if it is valid on the person's control, then in addition to every sentence the judge in due case imposed by the judge should also order you to serve an additional period for committing that offense while under police control in this case, 1 year or times left on that period. And if that occurs, that would be served consecutively with sentence in the case. You also ordered to pay restitution to Scott Cooper, amount $4,438.91. You payable to the victim witness restitution escrow account to pay fees charged for that service. That is a substantive order. What that means, Mr. Jordan, is it's not going to go away. It's because you might serve your entire prison term. It will always be there. You can't discharge it in bankruptcy. There's 2 ways to handle it. Pay it or you die, whichever occurs first. All right. We're also ordered to pay court costs for judgment grant execution order. If you fail to do that, then the court could order that to be collected first by version of excluded levy on bank accounts related to federal assets. That doesn't cover it. Then in addition to then the court could order you to be served once you complete your prison term on life prison. They give you credit for your charge work, not a reset, for your charge work, reduce your judgment by that penalty and take control. According to the sheriff, you got 2 days in this county, they set to 18 for their time credit. Held another day and they take it back and get that credit. All right, anything further from council?
You said 2 days, and then what did you say about another day?
I just said that they'll take care of that at the present.
Oh,
Right now, we just calculate up to the date of sentence, and the prison calculates it. They get
right. I just didn't understand what you said.
Okay.
There's 2 days.
2 days.
Okay, thank you.
All right, thank you. You're remanded back to custody. Joseph Michael McClure is next. All right, are you Joseph Michael McClure appearing from the jail?
Yes, Your Honor.
Case number 22-0100, State of Ohio versus Joseph Michael McClure. It's a pretrial being conducted by Zoom. We're appearing from the jail. Counsel is Captain Hacker, appearing from the Zoom in her office, and plus the attorney Holland appearing from her office. Defendant's charged with rape and gross sexual exploitation. This is a first pretrial, final pretrial on June 1, and a trial date of June 27. Now, see that stated it provided a compliance with discovery and additional paper file as well. I don't see it here.
Yes, we did. We filed a notice of it on the 13th.
All right. All right. And your discovery is not yet been filed this matter.
That's correct.
All right. All right.
He does have, she filed on the 13th. I'm more efficient than I thought.
All right. Well, it's good to be efficient and not know it than to be inefficient and know it. So,
Exactly.
all right. Now, anticipating any retrial motions?
I'm not at this time.
We do have any, we do have one pretrial. And are there going to be any further witnesses from the state, any additional testing or expert opinions or anything of that nature?
You disclosed it.
No, I'm saying, do you anticipate any more coming in from your initial compliance?
No.
Okay, all right. All right, has there been a written plea offer provided?
There has, not everybody's actually on it.
All right. Okay. Any other matters to discuss at this time then?
There you are.
All right, thank you. All right, Clay Yoder is next.
Yeah, there was a competency request filed. He's
Okay.
inactive.
Oh, it has been? Okay, never mind then, we don't need him. We need Cheryl Pedder. They didn't take it off the dock. Yeah, I signed that on the 13th, okay.
That's Clayton Yoder.
All right, officer, we don't need Mr. Yoakum. We had order of competency on him, so I guess you didn't hear me. I yelled at you, walked down the hallway, not your fault. We need Cheryl Pedder, please. Who's the last that's yeah.
You're not gonna bring over the plea form for Beth Stewart.
Oh, okay. All right. Well then, while you're doing it, I've got a couple cases up here I can hear.
Okay, yeah, I just need to print it off and bring it over.
All right. All right, go ahead. We'll get to you in a few minutes, Ms. Stewart.
Okay, thank you.
All right, case number 220119. State of Ohio versus Cheryl and Hendrick. Are you Cheryl and Hendrick appearing there from the jail?
Yes. Yes.
All right, this hearing is being conducted by Zoom. Ms. Hendrick's attorney is Daniel Witt, appearing by Zoom from her office, appearing on behalf of the state, prosecuting attorney Anthony Collins. The defendant is charged with aggravated trafficking, aggravated possession of methamphetamine. This is first pretrial. Final pretrial is June 1, trial date is June 27. I don't see a witness here. Okay, I see a request for discovery that was filed. It looks like last Friday. I don't see that yet. I filed a check with Collins.
Yes, we have. We filed on the 17th.
Okay.
Along with our bill of particulars.
All right. So the files are full. They got the file, so they just said yeah. All right. You just made any pre-trial motions, Ms. Flynn?
No, none at this time, Your Honor.
And has been a written plea offer provided?
Yes, Your Honor.
All right, you're not aware of that, Ms. Witt?
Not yet. I will be out to see her this week.
All right. All right, any other matters that to discuss at this time?